Thank you so much for seeing me today. Today, Molefe.
You're welcome, sir.
Just to introduce myself and what it is I'm doing here exactly. I'm an independent journalist, and I'm working on a project that has to do with educating the average citizen on their rights as an employee, as a citizen, and whether or not those rights are being satisfied or being recognized by the labor market. My experience in the labor market has showed me that there is a terrible inequality between the employee and the employer. My point specifically here is to discuss what the CCMA is about. What is the CCMA from your perspective and from your experience?
All right, the CCMA, it's a dispute resolution institution which derives its powers or jurisdiction from the LRA. In other words, we operate within the shadow of the law. Now, we can only do what we are empowered to do in terms of the Labor Relations Act in trying to resolve the dispute.
Okay.
Now, our processes are as follows. We conciliate dispute, we mediate dispute, and if every else fails in terms of our jurisdiction, we can arbitrate those dispute.
Okay.
Now let me explain what is the conciliation process. When a matter is brought to the CCMA, the other parties having been served and being informed and alerted to the fact that a dispute has been referred to the CCMA will issue a notice to invite the other party to come and sit around the table.
Okay.
The first process would be a conciliation process. Now, that conciliation process is off the record. It is without prejudice, and the destiny of the process rests in the hands of the parties, employer and employee.
Okay.
The presence of the commissioner will be to ensure that the process is smooth and give guidelines in that process. Now, during the discussion, the commissioner does not have any decision-making powers.
Okay.
It is the parties who will make a decision whether to reinstate the employee, to re-employ the employee, or to compensate the employees.
Okay.
Now, the commissioner will give guidance if it's a dismissal dispute, which was referred within the 30 days period. Remember the statutory requirement, you refer a case to the CCM within 30 days from the date of dismissal. If it's a later date, within 30 days from the employer making a decision, meaning if there's an appeal internally and the employer makes a decision later, that date we start counting our 30 days. Now, if everything is in order, everything is equal, we'll conciliate the matter. In the absence of anything being raised, we'll conciliate, and in that conciliation, it's a user-friendly process. We're not looking for any evidence. We're not finding wrong or right. It's about resolving the matter. It's a win-win kind of a situation.
So just to understand the conciliation process, it's basically to facilitate an environment where the two parties can have a discussion and resolve the situation themselves under the guidance of the commissioner.
Absolutely. Now, in that process, we normally say, no, we're not looking for evidence, witnesses, documentary recordings, or whatever. Here we are saying, reserve your right for now to go to arbitration. Let's see if we can amicably resolve this matter. If we do, we'll reduce it to writing. And in that process, if it becomes necessary to separate the parties where the commissioner wants to discuss with other parties, so be it. And if it's not necessary, the commissioner at times may even say, okay, because you had a relationship, I can see there are no hostilities, would you like to have a private discussion? Then I'll step aside, allow the parties to
discuss it.
It's a second bite to the cherry, kind of, where the employer has made a decision, and now we are afforded a second chance at both parties to sit and discuss. And nothing is going to be imposed on any party. If they feel like, no, we're not agreeing to the terms of the settlement and we want to go for arbitration, where we will lead evidence and there will be cross-examination, is their right.
Okay.
If it comes to that point where we realize that, look, we're not finding one another as parties here, the commissioner will say, okay, I'll issue a certificate, and then you as an employee will apply for arbitration, or the matter will go to the labor court, or we can consent to the arbitration by the CCMA, even if we have the right to take the matter to the labor court.
Okay.
However, if it is a one-stop shop, that hybrid process where it's a con/up,
Yeah.
we conciliate. If we fail to reach any agreement, we arbitrate at the same time.
Okay.
In the absence of an objection to arbitration in terms of Rule 17 of the CCMA. You have a right to object, but it will depend. For issues of probation and issues of the basic conditions of employment. Entitlement to monies owed to you,
Yes.
etc.
Yes.
That will have to arbitrate.
Arbitration, okay.
Yeah, unless if the other party will now apply for a postponement, which we don't grant easily.
Okay.
Because when you grant postponement, you also consider the inconvenience on the other party. They might have traveled, paid for accommodations. If it's an employee, same thing, traveled. At West, you said these are vulnerable employees. They slept at the station, they washed in the toilet, they come from Limpopo or whatever. It's quite an inconvenience. So in the interest of fairness and social justice, we cannot just willy-nilly postponement is not there for the taking. We have to apply our mind. And at other times, even ask the other parties, are they willing to have this inconvenience, are they willing to mitigate that inconvenience, and then based on those factors, we may say we grant, but we don't easily grant postponement.
So arbitration is more of a legal process because it involves a formal investigation in terms of the factors of the relationship and what's going on there? Or?
Yeah, if we fail, then we go to arbitration. It means as parties, you must become prepared to lead evidence and to prove or disprove certain facts. Which evidence must be reliable and consistent. And at the end of the day, now it is the commissioner that will decide, and you'll get an award after 14 days. If maybe the commissioner did not apply for extension,
yes,
then within 40 days you are expected to have received that outcome. However, we are very cautious it's a right, we don't take it away, but we normally advise parties, let's explore the conciliation and see if we may be able to find one another.
So the arbitration process, does it take place in the labor court, or is the labor court only coming after the arbitration process?
Okay, remember, there are matters where the CCMA has got jurisdiction to arbitrate.
Okay.
Others, the CCMA does not have jurisdiction. Those matters have to go to the labor court. However, if there is a consent to give the CCMA the powers to arbitrate, if they don't have jurisdiction, the CCMA will arbitrate. But other matters, we have an automatic jurisdiction once the matter is referred to arbitrate. Let's say it's a dismissal and the party refer the matter. It's a sexual harassment issue, we conciliate, and the party elect to the CCMA to arbitrate, will arbitrate irrespective of whether the employee ends below or above the threshold. Sexual harassment will arbitrate. However, if there's any other discrimination issues, we'll look at the threshold. If you end below the threshold, then you have a choice to give us to refer the matter to arbitration or labor. If you are above the threshold, then there must be consent before we arbitrate. Otherwise, in the absence of consent, the matter must proceed to the labor court. That's why we explain that at times you must consent as parties. If you do so, then we are quick as the CCMA, inexpensive. Our turnaround time is very brief. We have a right to go to the labor court, there may be cost incurred, and the time factor, there may be a delay. Your case
of course, it takes a bit longer.
So
if one of the parties does not accept the decision that you arrived to through arbitration, then they can take it to labor court.
Yes.
But does their unwillingness to accept the arbitration decision count? Is it that taken into consideration when the matter is brought to the labor court?
All right, let's say you're not happy with the outcome of the award. Then in terms of Section 145 of the Labor Relations Act, you have a right to go for a review of the award. You must also provide security. If maybe the award says you must pay a certain amount, you must upfront put that amount to say, yes, whilst I'm waiting for a review, I put in this security upfront, and the labor court should be made aware in the other part, so that when you lose the case, the money is readily available. If it speaks about money. If it's reinstatement or reemployment, also you are not agreeable, that does not speak about money, then, but you have to prove to the other party that I have applied, but application to the labor court does not take away the right of an employee to enforce that award.
I see.
Yes.
So basically, one thing that I noticed in your mission statement or your mandate statement, if you'd like to call it that, democratization of the workplace, right? So given the services you provide, both the employee and the employer in this case, when they have a dispute, how would you say your services democratize the workplace?
All right. Remember, your Section 1 of the LRA talks about the purpose of the Act. Now, the purpose of this Act is to advance economic development, social justice, labor peace, and the democratization of the workplace by fulfilling the primary object of the Employment Relations Act. The democratization that you're talking about, participation in decision making, the right of an employee to also be recognized as somebody who contributes to economic development, to social justice. Every employer is obligated to promote justice in the workplace, so that it recognizes the inherent dignity of every person in the workplace. And therefore, we must make sure that when we handle these matters, we are very sensitive and alive to the history of this country, where we come from inequality, and that's why you have your Employment Equity Act that also reminds us and reinforces that principle of social justice and fairness within the workplace, where people are treated with dignity.
So understanding what you've said, you said that the employee has now the right to contribute to the economy.
Exactly.
Okay. Let's unpack that a little bit. So are you saying the employee now has a right to apply for employment? Is that what you mean when you say?
If it is available.
If it is available.
Yeah, if once the employer has got a position that they advertise. Remember, we cannot create a position that's not there. It's the prerogative of the employer in terms of the operation.
And so on,
Then you have a right to apply for that position.
Yes.
And whether you have a right to be shortlisted and interviewed is another matter.
It's another matter.
Because every job has got its own specs or job descriptions.
As you've heard, the CCMA is not really about representing you, the average citizen, meaning the employee. They more represent the state, because their only interest is in making sure that employment processes or disciplinary processes within an organization, as they affect the employee, are followed in accordance to the law. That's what they care about. They're not really there to represent you or the employer. They're only there to make sure that should you and your employer be fighting on any reason, that after you fail to resolve that situation between the two of you, right, any processes that were followed were legal and they complied with the law. That is what they cared about. So the expectation is that should you have a problem with your employer, you first try to resolve it between the two of you, internally being within the organization. If that fails, then you as an employee can call upon the CCMA to test whether or not the procedure, not to represent you, to just test whether or not the employer followed procedure in accordance to the law. Understand that. So now when it comes to answering the question, what can you do to equalize your position within the employment relationship, it doesn't seem, at least not yet, we still have the rest of the interview to go through, that the CCMA is the answer. It doesn't seem like they're the answer, since they don't represent you. Therefore, they cannot prop you up to equalize that inequality. What I found interesting during this portion of the interview is that when we were discussing the democratization of the workplace, Commissioner Molefe mentioned the employee's right to participate in the economy, or to participate in economic development, as he said. Now, he basically spoke about this, and this is where essentially where I felt I was thrown off, is that he spoke about it in terms of the employee having the right to apply for available employment. And he spoke about that right with reference to issues of equity. So with issues of fairness in selection, right, of the employee amongst other employees, whether or not the selection process is fair in equating the differences between employees to ensure that the best person is chosen objectively. So, look, equity is an important issue when it comes to fairness. It's just not the issue that I was focusing on or I was targeting with this interview. And like I said, the goal of the Golden Egg Workers Resolve is to question the employment relationship. So that is the relationship between the employee and the employer, not the differences between employees and their treatment in the workplace, because that's what equity, I think, deals more with that. So although it is an important issue, it is really not under my radar for the purposes of this video and this video series and the article.
Lucas.